The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everybody, and welcome to today's session, which is the second under the series called Transboundary Water Governance for Water Security, which is presented to you by the Big Data Analytics and Transboundary Water Collaboration for Southern Africa and its partner, the Sustainable Water Partnership, managed by Windhoek International and Tetra Tech with the IUCN Water Program. Today, we have another session with Dr. Alejandro Hiza, but before I introduce him again to you and give him the word, I would just like to remind you of 4 important rules for the webinars. And first of all is to keep your microphone on mute during the presentation. Secondly, to use the chat to exchange comments and ideas with each other during the presentation or the discussion. Third, to use the question tool to ask questions during the presentation so that we can look at them and prepare them for the Q&A session. And finally, if there is a discussion that you would like to intervene on with a relevant point or addition to what has been said, please raise your hand and you'll be given your turn to speak depending on time. We begin now and we're going to run until 4:30 today. And once again, I would like you to welcome Dr. Alejandro Hiza, who is the head of the IUCN Environmental Law Program. Prior to joining IUCN, Alejandro was a lecturer of international law and international law of the sea and law of European integration. And then he joined IUCN, and it's a little bit of the history of the environmental law program. So thank you, Alejandro, for your time today again. And we look forward to a wonderful lecture just like we had the last time. Thank you.
Thank you, Clara. Good afternoon, good evening, good morning, everybody, depending from where you are listening or participating in this webinar. Today, we have a follow-up webinar to the one that we had last week. This one relates specifically to international water law and governance. You might remember, for those of you that participated in the previous seminar, that last week we covered the issue of national water governance and its relations with water management. For today, I'm proposing the following outline. We will immerse ourselves in the issue of transboundary basins, and from then on explore the main governance underpinnings, especially in the area of law, looking at the evolution of what we know or we call today international water law, its scope or range of this discipline, explore some of the key principles, the so-called procedural rules, say something about water institutions, especially those that deal with transboundary rivers and lakes, and then give you a brief idea on some of the most important global instruments relating to international water law. With that in mind, let's get first to look at the scope of these transboundary basins. Looking at the planet, you see that all what it is marked there in blue are these transboundary river and lake basins. These are approximately 310, but there are also more than 500 transboundary aquifers. That means, you know, underneath, which is something that we do not see, there is also water that is shared between 2 or more states. But more importantly, why do these waters or basins or aquifers matter? They matter for many reasons. They matter because many people live within those territories, you know, not necessarily in the water, but around the water or surrounded by water and depending on the water. And look at, for example, those headlines, you know, that you can see in the screen before in front of you. Yes?
Clara, we cannot see your screen.
Oh, pardon.
cannot see it. Sorry.
So there is a problem, obviously.
Production. And I was waiting for it to come online.
Oh, so sorry for that. Oh my God. Just 1 second. And here I have something that says I need to show you my screen. I cannot go to that because for some reason, just 1 second, huh?
Mhm. Sorry, everybody. We just had a little technical glitch, and we're going to resolve it now.
Mhm. Oops. Just 1 second, please. Can you hear me at least?
We can hear you very well. Yes.
Okay, well, this is already something. And I thought it was everything installed. Just 1 second, please. Tengo un problema, por favor. ¿Puedes venir? Just 1 second. Se me cortó toda la comunicación. No pueden ver la pantalla. Yo no puedo ver mi pantalla. Mira, se me cortó esto.
Hello?
Yeah, they can hear me.
Yeah, we can hear you very well. It's just that
Use
and I've given you the
new
present,
audio.
so you should have received like a little notification to say to make your screen available because I've given you the presenters, right?
Yeah.
Display settings.
Display settings, yeah. Swap. Doesn't work. Doesn't come. Doesn't reflect here anymore. I don't know. Mhm. Mhm. No puedo llegar acá. No puedo llegar acá. Sorry, there is no way. A ver, wait a minute, wait a second.
We found the solution.
Now, can you see my momento? Just 1 second. Can you see now my presentation or not?
No, not yet. It still says waiting to view Alejandro Hiza's screen. So there's
And
some
I don't see.
message that you should click on to share your screen.
¿No? Como ahí, esto. Espérate, no puedo llegar, Diego. Clara.
Perhaps, Clara, can you send us again the request for share the screen?
Yes, so let me try and do it again. I'll stop
Say
me.
that again, because obviously it's not.
You're not seeing it.
No.
Yeah, wait a second, let me redo it.
No, I have here transboundary. I see only the photos.
Okay, so now I'm gonna give you I'm gonna make you presenter, so you should receive something that says share your screen.
Mhm.
Yes, now show my screen.
Yeah.
Can you see it now, Clara?
Perfect. Thank you. Now we see it.
Is it okay?
Yeah, perfectly clear.
Good.
Thank you.
So, excellent. So, in that case, what I'm going to do is, again, go back to the point in which I was introducing to you the first slide, showing the extent of the transboundary basins, meaning not only the international rivers and lakes, but also considering that more than 500 transboundary aquifers are in the world, and the significance of these transboundary waters in terms of the number of people that live in those territories, not necessarily, as I said, in the water, but surrounded by water, depending on the water, but also subject to a number of challenges posed by those waters in terms of disasters, in terms of availability, in terms of the effects through water from other phenomena like climate change. Is quite substantial. You are most probably familiar with some of those challenges. I'm just mentioning some of them here, and these are the ones that primarily have been subject of consideration by the body of principles, rules, and norms, which is nowadays called international water law. And I'm talking about not only unsustainable practices in terms of water use, but also other resources use having an impact on the water, overfishing, mining, and obviously the development on infrastructure. But going further into this idea of what this body of principles and norms relate to, and the situation nowadays of this body of principles and norms, we can say that approximately taking into account that 60% of the global water resources are transboundary, the most important feature for you to keep in mind in this particular case is that out of those transboundary resources, 60% of them, more than half of them, do not have a framework that establishes some kind of cooperation between the countries that are sharing those waters. And I think this is a significant figure, a significant number for you to keep in mind. What is the situation in which between 2-3 countries there is a cooperative framework, and what happens when this cooperative framework does not exist and the resource is shared between those countries? This is an important question. Following on that, I would like to refer very briefly about the ways in which that body of norm that now supposed to be applying to 60% of the water available around the world evolved over years. And I think here there is a lot of information that you will see in the following slides. I'm just going to highlight what I think is the most important, what are the most important elements for you to keep in mind. The most important element to keep in mind here is that international law did not originate around the concept of basin as we know it nowadays, but through the idea of rivers. And why was it so? Because the primary use of the waters, apart from being for human consumption, was from navigation. And you do not necessarily navigate through a basin, you navigate through rivers. And that's why the rivers were the primary focus for regulation throughout the history, until more recently, in which the international community started to establish certain principles and certain norms to regulate what we now call river or lake basins. And that was specifically in the auspices of several international organizations, like, for example, the International Law Associations, like the Council of Europe, or like the United Nations, for example, through the United Nations Watercourses Convention of 1997. But to that, I will refer in a minute. Important to say is that water law exists already for many, many, many years. I will say thousands of years. And one can say that even 2,500 before our time, Sumerian cities like Lagash and Umma crafted what can be considered most probably the first and foremost, the first international treaty regulating or bringing to an end a water dispute over the use of a river in which both city states in Mesopotamia, in ancient Mesopotamia, had an interest. So keep that in mind. Even 2,500 before Christ was born, there was already a kind of, obviously, an initial agreement between two Sumerian states regulating a dispute over water. More recently, and primarily through, I would say, 1800s and 1900s, started the European countries to regulate navigation and equal treatment of riparians in international rivers, and one way or another regulating international cooperation over waters. There are several relevant instruments. One of those was the Congress of Vienna that brought to an end, the Napoleonic time in Europe, and also following that, a number of treaties that gave birth to important international agreement and important institutions like the one that I will refer in a minute. In 1892, an important treaty established the International Commission for the Regulation of the Rhine. And nowadays, this particular commission can be considered one of the, I would say, the most advanced, the one that suffer through several ups and downs. There have been war between the countries members to that commission, but the commission, one way or the other, survived. And I think this is a testimony of the importance that institutions like that have to regulate and to bring, one way or another, a certain level of certainty and framing in cooperation between countries sharing a river or being riparian of an international river. Also, it is important to say that after the First World War in the Treaty of Versailles, there were important decisions being taken in terms of irrigation, fisheries, and navigation. Unfortunately, we do not have much time here to speak about that, but I think it is important for you to remember that also after the First World War in the world, there were some decisions in that treaty that relate specifically on water. You might know that in 1966, an important body of rules was adopted, not by the UN, but by an academic institution called the International Law Association, and these are the so-called Helsinki Rules on the use of water of international rivers that were very much, I would say, a starting point to what came after that during the 20th century to be called, as we understand, the modern international water law, or as we know it today. I would like to make here a little break to see if there are any questions, any points for clarifications before getting further on to explore the scope or the objective of the international water law as we know it today, having covered all this historical evolution, even in a very brief and quick manner. Thank you.
Thank you very much, Alejandro, for this historical overview. I always find them fascinating. We have a raised hand from Jacqueline King. Can I unmute you and you can ask a question or make your intervention?
Super.
Thank you, Jacqueline.
I haven't a question. Sorry, must have pressed the wrong button somewhere.
Oh, okay. A hand raised. That's why I thought. Thank you. Okay. I don't see any questions tonight apart from thank you for the
Super. So in that case, let me continue, and probably later on there might be some other question, because at the end of the day, what I just presented is a bit of background, but I insist the background is very relevant, I would say, to understand what is the status of this discipline and the importance that this discipline has nowadays to regulate important resources that are, as we saw in one of the first slides, covering 60% of the surface of the Earth. What is the objective? What is the scope, of this body of law, of norms and principles? What does, at the end of the day, international water law include or regulate? Does it include in a basin the main river? Does it include the boundary rivers or successive rivers, depending on how the borders, the political borders, between the countries are established, meaning that on one shore you have one country and on the other shore there is another country, or there is a successive river, like, for example, the Okavango in Africa, like the River Plate in South America, or the Amazon in South America, or the Mekong in Asia, in which you have one country following the other. So parts of the river, the countries are located successively from the beginning until the end of the river. Or does it only cover surface waters or groundwaters together? And what happened with the land surrounding all that? Well, these type of questions that I'm posing in these presentations have been the fundamental piece of the discussion between the lawyers, between the politicians, and between those practitioners that have been confronted with those questions over the years and have given, the impulse and the impetus for this body of law and norms to be defined the way it is defined today. And here, I think I have to insist on a distinction between what we call the basin, as you know, the river basin or the lake basin, and the watercourse. And I'm using here two definitions, not with the intention for you to understand or to look at, to memorize, the definitions, but to show you the differences between one and the other. And I'm taking the definition of transboundary or international basin as defined by the International Law Association in the Helsinki Rule, and I'm using the definition of watercourse as defined by the UN 1997 Watercourses Convention. And the distinction, as you can see in the slide, is quite important, but not so apparent. And this defining element there, as I said, to distinguish the idea of the basin vis-a-vis the idea of the watercourse, is that the first one is defined as a geographical area, whereas the second notion is defined by a system of surface waters and groundwaters, right? And this is what I would like you all to retain, that whereas the definition of basin look at territory, geographical area, the idea of watercourse is defined by system of waters comprising surface and groundwaters. With this conceptualization in mind, let's look at what the law says, what international law and the treaties about these issues say. The 1997 Convention does not use the concept of basin, but a more restricted concept, which is the one on watercourses. And as I said, is defined in Article 2 as a system of surface water and groundwaters, right? This is very important for you to understand, and most of you will probably think, so why, if from a management perspective, and many of you know about water management much more than I know, the basin is, so to say, the most adequate scale to manage waters, including transboundary. So why international law does not reflect what management requires from a practical point of view? And this is something that has to do with the evolution, the way in which over the years the norms and the state practice have been evolving, to which I will be referring in a few minutes. So bear with me, I'm going to respond to that question, and if not, please let me know, and I will be more than happy to say a few words about that. But having come to that point in which we define what is the state of the art of international law as far as the scope of transboundary waters are concerned, we need to look at something that is, for me, one of the most important pieces to understand what international water law is about and what is international water law for. And for that, we need to look at the principles. And why do I insist so much on the principles? Simply because not only the principles are, as you can see and as I have conceptualized them in the slide in front of you, the tools that explain the sense and the extent of the law, including not only the national norms, but also the international norms, meaning the treaties, and tell us something about the ways in which that provision, that law originated and developed. And it is so important because the laws and the treaties can be amended, can change, but the principles stay because they inform us about the origin and the development of the law. So if we do understand what the principles are meant to be for, we will understand what is the scope and the objective of the regulation that comes through the law. And that's why I insist so much in understanding the principles. These principles are also important, not only because they reflect state practice. You know, it's not because someone from the outer space comes to the planet Earth and tell you humans, you have to follow those principles to regulate the waters that you share with your neighbors. No, they originate in practice, and the practice goes back in time and to the 2,500 years before our era, in which these two Sumerian cities established, you know, peace after the dispute over the waters of the Tigris River. So during so many years, the states have been evolving in the way in which they've been approaching these matters, up to now, in which these principles are also recognized by national bodies, in some cases by national law, national constitution, and certainly by international tribunals when they have to define disputes or settle a problem between two or more states. And these principles, as far as water law is concerned, are primarily four. The mother principle of international affairs, international law in general, beyond and above water and any other resources, is the principle of cooperation. How, if it is not through cooperation, that two or more states can come together and discuss and decide on matters that do not belong to them alone, but are matters of common concern because they pertain to more than one state, if it is not through dialogue and through cooperation. And deriving from that principle, fundamental international law principle of cooperation, we have three that are distinct from, from international water law. One is the principle of equitable and reasonable utilization. The second one is the no harm principle, and the third one is the principle of protection of ecosystems. With your permission, I will go one by one and try to give you the essence of each of them. Starting with the principle of cooperation, as I said, this is the mother principle of international affairs that regulates all diplomacy, all diplomatic relations between states, not only as far as waters are concerned. The idea of cooperation, how does it manifest cooperation in international waters, in shared waters, in transboundary waters, no matter how you call it? We're talking about resources that cross political boundaries between states, manifest itself through a duty to consult with your neighbor, with your neighbors, and to negotiate in good faith. What does it mean to negotiate in good faith? Simply negotiate with the intention to reach an agreement. So you would like to build a bridge, you talk to your neighbor and you say, hey, how can we do to have a bridge that crosses this river so that your people can come to my country and my people can cross to your country, and all this with a view of trying to find a solution and getting to a compromise in a way that reflects the interests and the benefits of the two parties. This means negotiating in good faith with an idea of trying to reach an agreement that is beneficiary for both countries, or reflecting at least the interests on both countries. More recently, some international tribunals have said that the idea to conduct a meaningful environmental impact assessment when there is a risk to create a transboundary impact is part of this idea or this duty of cooperation. And this is something that came very clear in one particular judgment that was pronounced by the International Court of Justice in The Hague on the Uruguay River basin, dispute between Argentina and Uruguay over the construction of paper mills on one side of the river, specifically on the Uruguayan shore. And in that decision, that legal decision, the international court said that EIA is part of the principle of cooperation, or should be considered as part of the principle of cooperation, when there is a risk to create a transboundary impact, an impact that can affect not only the territory of the country that is conducting that particular project, but also having an impact beyond the territory and the jurisdiction of that country. The second principle that we need to discuss here is the principle of equitable utilization. Within the experts of international water law, it is said that equitable utilization is the most important principle and the most distinctive principle to regulate the relationships between two or more states as far as international waters are concerned. This principle is the application of the idea of equity into the use of waters that do not belong to one single country. Therefore, the fundamental or the underpinning here is to understand that shared waters are not subject to equal division, but equitable use. How can you subject waters to equal division when waters cannot be divided half and half? Because by its very nature, the water cannot be divided. And therefore, law came with this idea that as you cannot divide the water as you divide the territory, what you have to do is to apply a principle that reflects equity in the use of those resources. So, in other words, this idea of equity has to be translated into trying to find a balance between all the interests, all the uses, and all the needs of the countries that are sharing the basin, right? How, at the end of the day, do you get to have this balance of interests, uses, and needs if it is not applying the principle of cooperation. That's why I said, don't forget that cooperation is the mother principle, not only of international law and international water law in particular, but of conducting international affairs and diplomacy overall. So at the end of the day, the proper implementation of equitable utilization and reasonable utilization as far as water is concerned requires the hand of the principle of cooperation to obtain the benefits, the protection, and the development that you need of a common resource, which is a transboundary or a shared river. Ideally, and this is what I said to conclude, that requires a joint institution or a joint platform through which that dialogue and that cooperation operates on a permanent basis and operates in such a way that constantly there is a dialogue between the parties or the countries concerned to find a reasonable way to balance out those different interests, uses, and needs. International law, and especially some of the most modern treaties, have also established a number of factors that can be used to determine what is equitable and reasonable and what is not. And the experts in this field all agree, and also because international law so dictates, that all the relevance have to be considered together, and there is no one factor that has priority over the others, as it has been the case over some of the international disputes that still exist around the world relating to the uses of international or transboundary rivers. What international law recognizes, although it says that all the factors have to be considered together and all of them have to be pondered to reach an agreement, you know, in a particular case about divergent uses of the river, special attention has to be given to the requirements of vital human needs. So, in other words, you can consider environmental aspect, you can consider a climatic aspect, historical uses, economic factors, and so on and so forth, but vital human needs have a priority. Having reached some consensus, I would say, even if we do not have the opportunity to talk so much, and I'm the only one talking in this presentation, but I think you understand what I mean, of what are the basics of what equitable and reasonable utilization. Let me now get to the third principle that I would like to discuss this afternoon with you, and it is the principle of no harm or no significant harm. And this is something, this is not an easy one to understand, because one could think that if you define a principle by saying it is no harm, it will mean that if you cause any harm, you know, into the environment of an international or a transboundary or a shared river, it's going to be, you are going to be responsible or liable. In other words, anything that you do that might alter the physical characteristics of a river and its water and its resources will be illegal. And this is not. International law, when it speaks about harm, speaks about, first of all, the qualification of that harm as significant. In other words, you know, it has to be to a certain extent meaningful. Not any harm is prohibited by international law. And therefore, you know, here, the way of analyzing the harm and the response that the country causing harm, the way that this response has to be is by way of looking at the diligence level applied by that state in causing that harm or not causing that harm. And therefore, we speak about an obligation of due diligence. In other words, how diligent have you been in trying to avoid the causation of that harm? In other words, have you established or have you done all what it could have been expected from you as a responsible country, as a responsible society, to avoid in the use of those waters causing a harm, causing an impact that is transboundary, that is affecting other countries or the environment in general, or the areas beyond national jurisdiction. So retain that, maintain that idea that not every harm per se is illegal. In the best case scenario, or the best way to address that matter, is to analyze what are the activities that might cause transboundary impact or transboundary harm, and decide on a case-to-case basis what are the necessary measures to be established to control that harm on a bilateral, on a trilateral, on a regional level. This is due diligence. The meaning, I think I said that, but I will explore that further with you. As I said, significant. Significant means more than perceptible or trivial, and it is something that surely will have to be determined on a case-by-case basis, because every basin is different, every harm is different. The level of affecting, communities, populations, species is different, and it depends on every single circumstance. But all in all, that's why I would like to insist on that, is that you've got to understand that there is not a universal prohibition in international law to conduct activities that might cause harm. What you are expected as a state in international law is to act diligently. And if you cause harm, then yet you will have to be subject to rectify the situation. Eventually, you might be able to you might have to pay compensation and things like that. Therefore, the best way to regulate situations like this is on a bilateral or on a trilateral or on a regional level, trying to address those issues ex ante before they happen, and try to establish in a cooperative manner what could be the measures that you're going to take in case the harm really happens. Let me go now to the fourth principle, which is the principle relating to the protection of ecosystems. And here, the relevance of these principles, or this body of rules deriving from that principle, is or indicate a recognition of the ecosystem values and the functions, including those, or precisely those, that are the basin or the transboundary water courses. It includes also a duty to protect those ecosystems individually, or for those that are located within your territory or with your part of the basin, but also those that are located beyond the borders of your part of the basin. It has to be also with the control of the introduction of alien species that you probably know cater for one of the major risks to biodiversity, aside from human intervention, but also goes a bit further beyond in the sense of including the protection of marine environment and the estuaries that are associated to this idea of the watercourse. Remember that when I make that definition and that distinction between watercourse versus basin, I indicate that watercourse is not defined as a geographical area, as a territory, but as a system of waters, right? If you really would like to make a forward-looking interpretation of this concept of watercourse that looks compared to the concept of basin as a bit more restricted, because it doesn't include territories, it does not include the area beyond, so to say, the waters. But if you look at, for example, provisions like these ones that relate to the protection of ecosystems, then the difference between watercourse and basin become a bit more diffuse. Because provisions like these that speak about the protection of the environment, not only the water, the environment, and also beyond the waters themselves, including estuaries and the marine environment, bring the conceptualization of watercourse very close to the idea of the basin as it was defined by the 1966 ILA Helsinki rules. Having said all this, which is, I know and I recognize quite a lot, and certainly it is not my intention that you remember all this. As I said, remember what the principles are, remember at least the essence of these principles, because if you understand the principles, then you will understand the law, meaning the national and the agreements. I have to say something about what in international law and in international water law are called by the procedural rules. And why is it so that it's important to speak about procedural rules? Because these rules are the ones that provide the practical means to implement the principles that I just referred to. So if you do not have the mechanisms that provide, so to say, the operational framework for the management of the watercourse to operationalize, as nowadays we always say, the rules relating to cooperation, to equitable and reasonable utilization, to the avoidance of harm, and to the protection of ecosystems, law itself is a little bit meaningless. That's why you need to understand a little bit about these procedural rules. And these procedural rules, again, are established normally by treaty. And some of the treaties that I will refer later on speak about that. These rules are, are quite many. In the screen that I'm putting in front of you, you will see some of the most important ones. These ones have to do with exchanging information and consulting other countries on possible effect of measures that you as a country are planning on a transboundary watercourse, notified and provide technical data and information, provide further information when you are in the middle of a consultation if your neighboring country requires so. The duty not to implement, a particular measure until your neighbor or your neighbors have been satisfied, with the consultation processes and the information that you've been providing. And obviously, it gives you, as a sovereign country, always the possibility to proceed with the implementation of a particular project or measure, even without the consent of your neighbors, in those cases in which you need to safeguard important interests of public health, public safety, or some equally important interests. But primarily, this idea of procedural rules are the means and the mechanisms through which the cooperation, the other more static principles come into life. But more importantly than the procedural rules, or equally importantly of the procedural rules, are the institutions. Because those institutions, as I explained to you last Wednesday when we spoke about management and governance and the different aspects of governance, you might recall that I said that one key aspect of the governance, so to say, realm are the institutions. Why are the institutions so important for governance at the national level, equally at the international level, because they are the ones that operationalize the policy and the law and give real meaning to that. These are the entities that will be responsible for managing waters, national and international, and implementing all those principles, all those rules, not only the principles of equitable, reasonable utilization, but also putting in implementation, putting in motion all the procedural rules that give real meaning to the other principles. And these institutions may be formal, less formal, may be, bilateral, may be trinational, may be comprising more than that, may have a regional character. Some of them are called committees, some of them are called authorities, some of them are called commissions, for example, the Mekong River Commission, and so on and so forth. And some of them do not even have an office and are composed simply by regular meetings between agencies of the states or other entities of the states or delegates of those entities. But primarily, no matter how they are called, how formal they are, how much money they have, the importance of the institutions is that they become indispensable when states would like to regulate and when states would like to cooperate and would like to achieve optimal and equitable utilization and a sustainable management of a river, a lake basin, and even more, an aquifer as well. They coordinate the work between the different states, and they provide the platform and the mechanisms for discussion, for establishing joint management approaches, and also to trying to avoid potential conflicts over the use of the waters between the different states. One last word before making another short break for you to think about that is the issue of effectiveness. Because you might think about, yes, we have institutions, yes, what do we need those institutions for? But how, at the end of the day, we make sure that those institutions are effective. In other words, that those institutions deliver what they are supposed to be delivering. What are the factors at the end of the day that you need to consider when looking at the effectiveness of those institutions? Those institutions are as effective as the states creating those institutions would like the institution to be. So the level of authority conferred by the states creating that institution is key for the effectiveness. It is also key, or it is also important to measure the effectiveness, the level of cooperation that exists and existed prior to the establishment of those institutions. Most probably, the institutions are the end of the pipeline on the long history of collaboration between states that manifests itself by establishing a more permanent body to coordinate the dialogue, to coordinate the interactions, and to serve as a platform to continue expanding that dialogue and that cooperation between the states. It depends also on the economic and technical capacities of the states for implementation. For those of you that attended the previous webinar, please remember when I spoke that at the end of the day, governance is an issue of capacities. Effectiveness of governance, effectiveness of institutional arrangements are at the end of the day, in many cases, an issue of capacities, technical and economical capacities. It also depends on institutional design, because you might create a beautiful institution, might have a beautiful office with a lot of great people, but if you do not give them the right mandates and the right levels of competence to do their job, well, forget it. That's a recipe of disaster. Don't do an institution, don't spend money into that. And also, more recently, I would say, as all these mechanisms become more and more participatory and in which civil society is more empowered, depend to a great extent to the public participation arrangements that are established for those institutions to be not only top down, between states, but also looking at what the real users of the water that at the end of the day are directly involved and directly related to the resource at the local and immediate level, which is the public. And with that, I would like to open the floor for having a glass of water or attending any questions that you might have, and then get to the last part of my presentation.
Thank you very much, Alejandro. That was a very long and content-laden session. It requires me to go back into a lot of what I thought I knew of the reality of Southern Africa in terms of the content of the shared protocols, which is about water courses, but then it established the river basin organization. So now I would like to understand more about it now that I know that there is actually a difference law between the two. Between the two. So there is the very first question was from Kevin Peterson from the University of the Western Cape, but also a private consultant. And in the interest of time, because it's already 4 o'clock, I'm gonna pass you the presentations. Although I see that there's a couple of raised hands, so I'll attend to them just now. So Kevin would like to have a little bit more of an understanding of what is the concept of common terminus. And again, it goes back to the original definition on the Helsinki rules. And then the other one was from Osama, who wanted to know what are the aspects of difference between the practices embedded in the international water law and those embedded in the integrated water resources management, and why can't they be bridged in one regulation or law system? Thank you. After you address those, I will open to Jacqueline and Bangi from Rand Water because they had their hands up. Thank you.
Okay. Thank you. I mean, thank you for those questions, and I will try to be very brief in my answer. The previous one relating to the common terminus is very simple, and it's a definition. It's a way of, it's a definitorio definitional. I don't know if I'm using the right word, because English is not my mother tongue, but comes from a definition. In other words, here, the way of defining whether or not two rivers, that might be the main river and 1, 2, 3, 4 tributaries, are by virtue of their relationship, one watercourse or one basin is when the waters of those rivers, no matter which one is the tributary and which one is the main river, all the water come to a common terminus, which might be a sea, which might be, which might be another river, which might be a lake, or which might be an inland terminus, like it is the case in Southern Africa with the Okavango. That the common terminus of the different tributaries of the main Okavango River end in the middle of an inner delta in Botswana, right? But there are some other countries, some other rivers, for example, the Zambezi and the tributaries that end in the Indian Ocean, or the Volta that flow into the Guinea Bay in Western Africa, and so on and so forth. The idea of common terminus indicates that the relationship of the rivers constituting one single watercourse flow into one single place together. This is the idea of the common terminus. The question from Osama, I think the second one, is one that looks at, I guess, the distinction between governance and and management. And it is a matter that I try to explain as best as I could in my previous webinar, in which we define the governance arrangements as means, as mechanisms to give proper implementation to ideals of management, which is, for example, integrated water resources management. If I interpret that question correctly, I think that his plead, or probably what underlies his question is, why don't we have an international law that relates to integrated water resources management? And that might be, let's say, an aspiration, in the sense of having a body of norms that contemplate not only waters, but also territories and other resources that are intersected by the waters and the territories. But this requires coming across overcoming, I would say, one important aspect, that is the issue of state sovereignty. And the fact that international norms and international rules cannot be imposed by one single state, that they have to be agreed by more than one state. In other words, if we would like to push for a particular concept in international law, for a particular provision in the international law, we cannot say, I represent country X, and I think this is very good from a managerial point of view, and I think this is the way it should be. Forget it. At least I need the acquaintance and the agreement of more than one state that will say, okay, Alejandro, we will agree on that, and we will make it part of an agreement between the two of us. And that's the beginning of an international law. So, in other words, what it might be adequate and ideal from a management point of view, it does not necessarily reflect a correlativity or a correlation from a governance point of view, and especially in international relations, because you need to overcome state sovereignty. In other words, you need the agreement of two or more states for that governance arrangements to be established, so to correlate to that management arrangement that might be an ideal. And I hope that with that, I was able to answer at least partially the question coming from Osama. If not, we can continue later on, separately, and I will be more than happy to interact with him, later on that. If that is okay, I would like now, in the few more minutes that we have available, share with you some, I would say, basic information. Is never basic, because law is not easy, but I'm trying to make it as easy as possible for you to take some messages with you on what we call the selected instruments. I mean, it's impossible in a webinar of 1 hour and plus to give you a full, let's say, panorama of what are the main instruments that relate to international water law around the world. Because, yes.
Sorry, just before you continue, there is one quick clarification from Kevin on
yes.
who asked for the common terminus. He just asked very briefly, how does that definition apply to groundwater? So that of the common terminus. It just implies, yeah, go ahead, just very quickly. And then there is.
Let me get to that at the end of the presentation. Thank you. Thank you. It's a very good question.
And then we'll finish the Q&A. Thank you.
Super. I have written down here next to me, so Kevin, don't worry. I'm not forgetting you. Is common terminus in groundwater. Yeah. Looking at, as I said, the selected instruments, it will be impossible to give you the full panorama of what are all the treaties and all the agreements that relate to shared waters. because we will have to look at those of global nature. We will have to look at those of regional nature. For example, in Africa, the SADC Shared Water Protocol is an important one. In Europe, the European Water Framework Directive, and so on and so forth. And then look at all those specific ones that relate to regulation of specific basins, you know, ranging from small into big, into lakes, into rivers, and so on and so forth. What I would like here in this moment in time that we are now is to show you that the current status of law and the instrument that exists nowadays have been a process of evolution that, as I said, started, you know, many years ago, but especially in the 20th century, up as of 1911, when the Institute of International Law in a declaration, which is the one called of the Declaration of Madrid, stated, so to say, started the process of codifying all the existing rules that relate to international law as relate to water. Then we had, in 1921, the adoption of an important international convention which relates to navigable waterways of international concern. That was the name of that convention, but primarily that convention was to regulate navigation. Two years later, a similar convention was adopted, but not to regulate navigation. The idea was to regulate hydropower, affecting more than one state. Later on, as I indicated to you, we had the work of international bodies, especially of academic nature, especially the International Law Association, with the adoption of the so-called Helsinki Rules on uses of waters of international river. Here I would like to make a specific remark, because I have also seen that some people tend to confuse these rules, the Helsinki rules, with treaties, or consider them as if they were treaties, which is not the case. They are rules, but not rules in the legal proper sense, as if they had been adopted and negotiated by countries. In other words, they are legally binding. They are not. The nature of these 1966 rules is of recommendatory nature, because they were not adopted in a diplomatic conference, they were not adopted by states, but by an international academic body. They gave, obviously, the impetus to the adoption and the formulation and the adoption of treaties later on, but the rules themselves are not a treaty. The two most important global treaties nowadays that exist in the world to regulate transboundary water-related issues are the 1992 United Nations Economic Commission for Europe, the so-called Helsinki Convention on the Protection and Use of Transboundary Watercourses and International Lakes, and the second one is the 1997 UN Watercourses Convention. And I would like, in the few minutes that we still have available, to refer to some of them. I will skip the slides of those that do not relate to the two last that I referred to in the interest of time, but I understand that you will have all these presentations available later on. And go directly to the 1997 UN Watercourses Convention. This convention is the result of many years of work of the United Nations. that was adopted in 1997. That's why it is sometimes called the 1997 UN Watercourses Convention. Some of them call it the New York Convention. But the work that gave rise to this convention started more than 20 years before the convention was adopted within one particular body of the UN, which is called the International Law Commission. And that International Law Commission analyzed over more than 2 decades all the existing declarations, resolutions, agreements, and so on and so forth relating to international water law, with the view of trying to compile and codify in one single instrument that body of law, and presented draft agreements that later on were adopted by the United Nations General Assembly into this convention. When the convention was put for vote at the General Assembly in 1997, 103 states voted in favor, and 3 subsequently informed the UNGA that they were intending to vote in favor. There were 27 abstentions and 3 countries voted against. So the majority voted in favor. The problem is that no matter that the convention received such a positive, I would say, voting the moment in which it was put for adoption, the ratification process, which is the process that you need internally in every single country to manifest its intention to make that treaty enter into force, took some time. You can see here in this graphic that from 1998 until 2004, which was the moment in which the convention entered into force, because you needed 35 states not just to vote, but to ratify, to accede, or to accept that convention. Until that moment, the convention did not enter into force. From 1997, although more than 100 states said yes, until they got 35 ratifications in 2014, the 1997 convention was not enforced. And there is a lot to be said about that. There is a lot to be discussed about that, but this is something that we can leave for another webinar. Nowadays, these are the parties of this convention. Is a mixture of different countries in different parts of the world, with an unequal representation of certain continents. Is quite present in Africa and in Europe, very little if not non-existent in the Americas. I refer to the 1997 convention. I'm just going to give you some further flashes or some further information that I think it is important to supplement what I already said when I spoke in general about international water law. The scope is not the river or the lake basin, it's the international water course as defined by Article 2. The substantive norms of this convention are the 3 fundamental principles of international water law, and namely equitable and reasonable utilization, the no significant harm principle, and those associated to the protection and preservation of watercourse ecosystems. Also, the UN Watercourses Convention establishes a set of procedural rules, as I explained to you, those rules that are necessary to put the substantive rules into motion, in other words, to operationalize those substantive rules. And they relate, as I explained before also, to cooperation, participation, exchange of data and information. All these All this with a strong emphasis on process and cooperation. The whole article of the 1997 Convention is full of principles and full of rules that are really geared towards that, operationalizing the three main bodies of principles and norms. Also important to be said is that the UN Watercourses Convention establishes certain provisions relating to management and said specifically that the watercourse states can or shall enter into consultations concerning management of an international watercourse, which may include the establishment of, as I said, an institution. In other words, the treaty itself, this convention, suggests or invites states that having joint management arrangements, in other words, institutions, is good for cooperation and for operationalizing all the provisions of the convention. And here we come again to the role that the institutions have, not only at the national level, but also at the international level in operationalizing governance as such, something recognized in Article 24 by the UN Watercourses Convention. And also, and this is very important, the UN Watercourses Convention places an important emphasis on dispute avoidance and dispute settlements. As any treaty coming from the UN, this is a UN treaty, parties are invited, encouraged, suggested always to resolve disputes by peaceful means. But the convention itself provides a menu, of different options to be used by the parties when they have a dispute, in terms of implementation or interpretation of the convention, going from negotiations up to having access to the International Court of Justice through fact-finding, good offices, mediation, conciliation, and arbitration. A final word to the other global treaty, which is the UNECE, the United Nations Economic Commission for Europe Water Convention, the Helsinki Convention, that preceded the 1997 Convention because it was adopted in 1992 and entered into force in 1996, whereas the 1997 was adopted in 1997 but entered into force in 2014. This is a convention that was agreed and was adopted under the auspices of a regional economic commission, the Regional Economic Commission for Europe, and initially was targeting those countries. But in 2013, an amendment to that treaty in one of the conferences of the parties allowed for global ratification. So nowadays, aside from countries that are members of the United Nations Economic Commission for Europe, Chad, Ghana, and Senegal, 3 African countries, are also party to those conventions that has been precisely allowed because of that amendment that allow for global ratification and accession. The scope is quite similar, the objective of this treaty is quite similar to the Treaty or the Convention of 1997. Also, the regulation of surface and groundwaters says that marked cross or are located on boundaries between 2 or more states. Also, in this treaty, the countries agree to adopt measures to protect transboundary waters, control pollution and the reduction of transboundary impact, also using the principle of equitable and reasonable utilization and the conservation and protection of, they say, the resource, but with a focus on ecosystems, placing an important emphasis on the duty to cooperate, going perhaps a bit more specific than the 1997 Convention in the duty to undertake an environmental impact assessment when one country is intending to do or to conduct a project that might have a transboundary impact beyond the territory of that state. And also, like in the other one, establishes the possibility to enter within the context of this convention bilateral or multilateral agreements to regulate basin and their specificities at the bilateral or trilateral level within, so to say, the framework on the UNECE Water Convention. Final, just a slide to put in front of you some of the comparisons. I think that these two conventions are complementary, so there is no point in saying that you can exclude themselves. They are very complementary one with each other. Both have the objective to enhance effective water governance in a transboundary level. So in other words, putting a strong emphasis on cooperation between states to seek or to obtain, maximum and sustainable use of the waters. The differences perhaps come from the way in which they arose. One was primarily European, whereas the other one had from the very beginning a global nature, or was from a global nature. And perhaps what I would say is that if one gets into very the specificities of each of them, the Helsinki Convention, the 1992 Convention, has more detailed provisions, especially in relationship with quality, and in that sense, going more into details on the principle of no harm, whereas the UN Watercourses Convention, the 1997 treaty, focuses more on equitable and reasonable utilization, and thus not only on quality, but also quality and quantity. And with that, I think I have to conclude, and thank you all for paying attention to this long presentation that I hope at least could give you the essence or some of the headlines and the highlights of this comprehensive discipline that is called international water law. My hope is that with this webinar, you now will be able to recognize the main principles, the implications of those main principles from a practical point of view. What are the main treaties, the global treaties that are and serve as a reference for the adoption of regional treaties and basin treaties. And then, if you would like to get further information, then yet we will have to take, either a new webinar or explore some specific literature, and I will be more than happy to share that with you if time permits, or on a bilateral way, or obviously through these webinars and through this partnership, we'll be more than happy to respond to any questions and to provide any further information. But first of all, I have to answer the question from Kevin that relate to common terminus in groundwater. I think that in groundwater, speaking about common terminus is not the same as with surface water, because groundwater do not have by its physical nature exactly the same behavior as the river of a lake in the surface water. Not being a hydrogeologist myself, I'm a simple lawyer that has been trying for quite some time to specialize on these issues, but as I said, I'm not a geologist. I understand that the behavior of aquifer, confined and non-confined, is not having a terminus. The aquifers are under the surface of the earth and are like a layer, I would say. They do not have a beginning, they do not have an end. They have areas of recharge, but they have areas of discharge. But whether of those areas of recharge and discharge can be considered as terminus or not, in view of the fact that aquifers do not have, again, I said it as a lawyer, tributaries. It's very difficult for me, I will say, to speak about common terminus in such a context, if you understand what I mean. Kevin, I hope that this could bring some light into your interesting question, but as I said, the lawyer might get it wrong. I guess, it's probably a question from a hydrogeologist.
Thank you. Thank you very much, Alejandro. There was also a very quickish clarification question from Nathan Bonham. He asked, do the principles of international water law come from the UN Watercourse Convention?
These principles have been reflected in the UN Watercourses Convention 1997, and I would say it's probably the best way to look at those principles, precisely because of the codification work that was taken by the International Law Commission before producing, the draft articles that gave life to this 1997 convention. So I would say the 1997 convention reflects in the most comprehensive manner the way in which those principles are, and the framing of those principles, and the boundaries of those principles. Because it is a work that took over 20 years, and there might be new principles upcoming. In international, in environmental law, we are speaking now about principles in dubio pro natura. We are speaking about principles like non-regression principles and things like that. Whether those principles are going to be one day, in the future, part of international law, part of international water law, is still to be seen, it's still to be said. But nowadays, it is probably the 1997 convention, the best and most comprehensive expression of the codification of those principles. Yeah.
Thank you. Ebenizar Shangiza also had a question, which he put down. So I think there was a bit of a misunderstanding, because he says you have mentioned that the key factor for effective institutions boils down to economic and technical capacity. But what about the legitimacy factor, and what about the value system the institution is guided by? What about the level of legitimacy that the institution possesses?
Super, absolutely. No. I was not meant, my factors were certainly not meant to be exhaustive, and not meant to be a kind of a numerous clauses. I just wanted to mention some that from my point of view came, to my mind. If I would like to evaluate the effectiveness of an institution, those are that I will certainly put or plead we need to consider. But sure, there are many more. This is not an exhaustive list.
Yeah, and I also think, like you mentioned, legitimacy as in authority, and sort of speaking about the mandate that the states that share the watercourse actually give to the institution. So I think it's a very similar concept. So in the end,
correct,
isn't that so?
Yeah, I mean, it's the same issue, but looking at that from a different point of view. In other words, I've seen in my experience, countries that have established, I'm not going to say one in particular, but situations in which you have countries establishing an institution to cater for cooperation and regulation of common resources, meaning by that, water resources. Given that institution, all the necessary mandate and attributions, even in the for the sake of managing a budget and attracting, you know, projects from international cooperation by the institution itself, given and granted that institution international legal personality, you know, independent from the states that have created that institution. But in the end, when the institution became quite autonomous in managing those funds, in attracting those resources from international cooperation, the state said, well, wait a moment, we didn't mean it to be that way, you know. It can happen, you know. Is it what the states wanted, you know, when they established the institution or not, you know? Is it the best way to cater for establishing a platform to help, you know, to set the path for better and deeper cooperation between the states? This is, at the end of the day, a question that relates to political will. I mean, we can look at that from so many different angles, right? But the essence is that the institutions do not happen, you know, automatically by themselves. Somebody establishes those institutions, and you know, and in this particular case, are the states. You know, who comes first, the institution or the state? The states. The institutions are normally created by treaty. You know, are they in a way the coronation of an agreement or a treaty that two or more states celebrated and created to manage a particular resource, and they say, from now on, you are in charge of taking care of our river, our lake, or something like that. So the effectiveness depends, at the end of the day, on all the competencies, all the attributions, all the resources that you give to that institution. Yeah. It's as effective as the states would like it to be at the end of the day.
Yeah, look, I think Eben was also speaking from experience because he's working for the Okavango Commission, if I'm not mistaken.
Oh, well, but we're talking about the person that has a lot of experience. I mean, Eben knows more than I know about all these issues. I have to learn from Eben.
Eben, would you like to comment on Alejandro's point? And then there's one last question from Wilkis Tarotieno. I have unmuted you, Eben.
I think that's okay. I mean, the point that I was trying to raise is sometimes you might have a situation that you just muscle your power simply because of your financial capacity and economic capacity, and then but not being in charge of very genuine purpose or very genuine mission, right? So how do we balance those two pillars? And then we have a number of examples that situations that specific partners are being bullied because of not having the three pillars appropriately balanced. So we need to find ways of protecting that aspect.
I mean, at the end of the day, you know, treaties and laws and treaties are there to be respected, that they can be changed, you know, and as a treaty can be changed and can be modified or amended, also, you know, an institution can also be amended and changed by way of the decision of those that have established that institution. I understand that, how can I say, you know, it depends pretty much on the objective that the states have at the beginning when they establish that institution, you know. Was the institution just to cater to serve as a platform for exchanging information or to bringing the countries together, you know, to discuss very specific issues, meaning navigation, meaning border, meaning this, meaning that, transportation, and so on, or was meant to be going beyond all that, and therefore from the beginning the countries have given that institution all the mandates and the authorities to go beyond one specific issue, you know, and also by way of the natural evolution of the institutional development, you know, institutions grow by themselves, you know, without necessarily having the state behind them that have given rise, you know, to that institution. Is at the end of the day an issue that goes beyond law, that has to do with a bit with, I would say, politics, that has to do with management, coordination, you know. Law can establish the principles and the rules of the game, but at the end of the day, the evolution is something that operates beyond the law. Yeah, you can attribute some of the failures in terms of operation and management of a particular institution to problems in the law, but in most of the cases, some of the divergencies that happen later on have to do with the way in which those provisions are interpreted or those provisions are applied over time. That's my take, my very personal view on the matter. Without saying anything about Okavango or saying anything about any particular river commission, any particular river or lake commission. Sorry. Yeah.
There's only one last question, but that you only have literally 5 minutes or less, because I know that you have another appointment soon. From Wilkistar, and he asks, what happens when you have transboundary waters that are being governed by agreements drawn decades and that are inequitable? I mean, I guess that's what you say. It's always about the states. The states will have to agree to change those if they are if they accept.
So the question, if you can repeat the question, Clara. So what happens if you have a transboundary waters that have no agreement in place, or what?
No, they are still being governed by agreements that were drawn decades, even centuries ago, and that are were inequitable, or they sort of perpetuate a sort of relationship of inequality.
Well, I can sense in which direction that question, or from what direction this question is coming, and this is certainly a very, very pertinent question. But you already responded to that, Clara, yourself. As the current situation, which is governed by a treaty that might be considered inequitable or superseded by the circumstances, because I don't know, the treaty was adopted, you know, under in colonial times, and you know, and the countries have evolved, and the social, political, economic circumstances have changed, and therefore, you know, there is all the ingredients for changing, you know, to adopting a new treaty. You will have to come to an agreement to change that treaty, and the only way to change that treaty is that the countries that are parties to it, or could be parties to that, come to an agreement to establish a new treaty. That's the way that international law operates. You know, there is no way to impose unilaterally a treaty upon another country. Law, international law, acts on the basis of cooperation and consensus, right? National law is a different cup of tea. In international law, that's why I insisted so much. The fundamental, the key pillar is cooperation. You know, if it is not through cooperation, nothing can happen. Through dialogue, without dialogue, nothing can happen. You cannot impose anything on the others.
Yeah. Okay, I think we have exhausted. Sorry. I think we have exhausted the questions and your time as well. Thank you once again so very much for your time last week and this week, and for these very informative presentations. We've had really good feedbacks and people interested in receiving the presentations, clearly because not a lot of us practitioners are well versed in the law, and so this is actually brings up a lot of points of clarity. So thank you very much for that. And you're welcome, of course, to take part in the other seminars done by your colleagues at IUCN and the Environmental Law Center to then contribute further to the sessions and the questions and the participants. I would like to...
I will.
Yeah.
I will. And if there is anything, Clara, and this is something, you know, for all the participants, you know, if there are any interest, because sometimes, you know, you might get to discover that there is something that you would like to discuss, or some information that you might need, or some exchange you might have, you know, we are available. You know where to find us, you know, in Bonn at the Law Center anytime. We will be more than happy to continue interacting with you beyond all this and continue exchanging information. I'm very happy, and I thank you all, you know, for your time and for bearing with me in this short and heavy journey through international water law. That is never finished, and I think it's still a lot of things to be said about that. But I think it is an important piece of the puzzle of this quest of trying to find the appropriate governance arrangements to resources that do not pertain to one single country, that have to be governed by cooperation, that require innovative approaches, but the only innovative approaches can come through dialogue and cooperation. And that's why we need to look at the law and what the principles governing that piece of law are saying about.
Yeah, couldn't agree more. Thank you for making that statement. And thank you everybody for joining. We'll see you again next week at the same time on the same link when we will talk about benefit sharing in water governance. Enjoy the rest of your day wherever you are, and thank you for having spent the last hour and a half with us. Thank you, everybody.
Bye. Super.